Cuthbert.
Is it on or do I? I got some paperwork here.
I would like to assist my son in his defense. And point of order, you are Ms. Jones? Terry Jones? You're not Terry Jones?
Would you like me to take a moment and read your motion?
Would you like me to?
Have a moment to read the motion?
Yes.
Or would you like to,
Can I ask a question or two first, point of order? Is there a recording device on in here? Is the city recording, is the room recording device on? Yeah, okay. Because this is a chapter 162 proceeding and not under traffic court laws. So you have to comply with everything that's under the magistrate code. And that includes fundamental due process. And if he wants to read that, technically everything I've heard in here just making my blood boil. Because we have constitutional rights, even in these hearings. And included in that is the right to presumed innocence under Coffey versus United States. United States Supreme Court, don't have the citation, but it is in that document I gave you in 1898, where the United States Supreme Court adopted the doctrine of presumed innocence for the United States as the supreme law of the land, and it traced it all the way back to the book of Deuteronomy in the Bible, traced it through the Roman Empire. It's included, presumed innocence is included in the Declaration of Human Rights. It's part of the United Nations Charter in 1948, Article 11. The only people that haven't recognized the doctrine of presumed innocence in the modern era has been Stalin, Hitler, Mao, Pol Pot, now the city of Palm Bay, the state of Florida, because whatever they passed in 210-80 laws of Florida is just unconstitutional as the city of Florida, or the city of Palm Bay's ordinance. I could ask you to recuse yourself right now because you're biased, you're acting as prosecutor and judge. We all have the constitutional right to be heard fully and fairly before an impartial tribunal. And with you being the prosecutor and the attorney passing judgment, that's just that is such a blatant violation of fundamental due process. It makes my head spin. And we have the right against self-incrimination. I mean, everything I've heard, you're asking us to convict ourselves, and nobody is presenting any evidence from the state. And you're the ones that have to prove guilt beyond a reasonable doubt, because these are penal hearings, even though it's just a magistrate hearing, it's not a court of law. But I understand you can't rule on these constitutional issues. Yes.
Let me please make you aware that this is not a criminal proceeding. And if you could please advise me of what rights are being denied you or your son today, if you could be more specific about that.
Do you just want to read the whole thing?
The rights being denied would be under section number 10.
Just read the whole thing.
Let's see. Pursuant to section 75.10 and 7511 of the Act, upon receipt of a notice of infraction, an owner of a vehicle may admit guilt and pay the fine on request of an appeal. Upon receipt of an appeal, the city shall schedule a hearing to occur no later than 60 days after the city's receipt of the appeal.
Did you receive notice?
No.
Not by certified mail, by email. I didn't know email was.
In Skelton versus Martin, District Court of Appeals, Second District.
Did you receive notice of the hearing today?
Not by certified U.S. mail, no.
Did you receive notice?
The way you're supposed to receive me notice, no.
You are here upon notice that there was a hearing today.
It was 11, yes.
You had the ability to come up here and contest
That's
this.
because I
Is
called
that correct?
yesterday and went to the clerk's office.
Mr. Cuthbert, I'm addressing Eric Cuthbert.
And I have case law right here that says computerized government Davis is not form of notice constitutionally guaranteed.
Sir, I'm very willing to entertain all of your arguments, but I can't be interrupted. I haven't interrupted you.
Okay.
Okay, Mr. Cuthbert, did you receive notice to be here today?
After searching it down, yes.
Okay.
So I don't know if that's receiving of notice or me looking for notice.
And this exchange that we're having right now, this is an opportunity to be heard, is it not?
Of course.
Okay. Would you like to state your objections to, or your grounds for contesting the actual ticket? Because right now what I have is evidence that is being presented against you. I'm evaluating that evidence. If you have some grounds for contesting the evidence.
I mean, the evidence that, what kind of truck was it? It's a blue Dodge, that's D-O-D-G-E, not, misspelled northbound on Malabar. Malabar does not run northbound.
There's also no time and date stamp
on the license tag.
There's no time and date stamp on the license tag photo. The use of speed evidence is a violation of Florida Statute 316.1905 and 1906, which preempts speed evidence to calibrated, approved equipment used by a certified police officer who must appear in a court of law or a traffic court or the hearing in order to establish the speed evidence was lawfully taken. And if the speed evidence, which I believe triggers your red light cameras, is used, it's all fruit of the poisonous tree after that. And the time between notice and hearing was 86 days, and your ordinance says 60 days.
I mean, at the end of the day, there's 4 keys to my truck. 4 different people have them. Space Coast is more liable than I would be because they own more truck than I do at this point. I mean, you can watch the video, the truck.
Have you seen the video?
I haven't seen the truck. I mean, I've seen the video. So,
Do you
it's
agree
not.
that the truck registered to you in the video did not stop?
I thought under code enforcement that you had to give a warning or a chance to correct the mistake.
Under 162.
There's no warning, there's no chance to correct the mistake. It's, the truck was driven at set time, and that's that. There's no warning, there's no chance to correct the mistake. It's, I'm guilty. Yes.
Can you explain to me again what was the fruit of the poisonous tree, Mr. Cuthbert?
Speed evidence. Under Florida Statute 316, all speed evidence is preempted to the state. And under 316.1905 and 1906,
Your suggestion is this is illegally obtained evidence?
Yes, because it's not obtained by it's not obtained by the 5 listed types of equipment listed in Florida Statute 316.1905, and it's not used by a licensed police officer, and that licensed police officer is not here to testify. That's Florida state law, that's preemption, that's our fundamental due process rights on the color of law. And if you're using speed evidence without a police officer, without certified equipment, without certified training, then everything else is fruit of the poisonous tree.
So you're saying because the device, the recording device, is not under the statute as a traffic control device, then it is illegally obtained? Is that your argument?